Sports law. Sports law is very interesting. It is very different from the common law or the civil law systems that we all know. It is actually a fusion of common law and the civil law systems. In fact, facts are very important in sports law. Its legal contents amount to perhaps 30%. And in sports law, circumstantial evidence is admissible. I emphasize, circumstantial evidence is admissible. And there is applications of Swiss law by default. So in a nutshell, this is the meaning of sports law. And sports law do give us a lot of fun, research, and joys. Next, please. Now, national courts. National courts of any country, they usually do not interfere in any decision of a sports tribunal whatsoever. In fact, there are judicial precedents to this, unless there is an element of criminality. So by and large, national courts do not interfere with the decisions of a sports tribunal. Now we talk about the Court of Arbitration for Sport, which is known as CAS. Our chairman and moderator, Dr. Ang So Chi, and myself, we are both fellow accredited arbitrators of the Court of Arbitration for Sport, or CAS. It is based in Lausanne, Switzerland. In fact, all Olympic sports federations and non-Olympic sports federations consent to its jurisdiction. Now, there is a two-tier structure in CAS. There is the ordinary arbitration, and there is an appellate level. So the structure is ordinary arbitration and appellate structure. As I mentioned earlier, Swiss law is very important. International sports arbitration are regulated by Swiss Private Statute 1987, and it is known as PILS. The arbitration is considered international as long as one of the parties, whether it's an individual, athlete, or the sports federations, they are not ordinary residents or domicile in agreement. At the time of the conclusion of the arbitrations agreement, now let's talk about scale of match fixings and corruption. Most of the sports law textbooks describe this as a mortal danger, and it's a cancer to the essence of sports. Such problems will definitely affect the integrity of sports, right? And it is due to a lot of speculation, cheating on the betting market. The betting market can be legal or illegal. Now, soccer or football, the next World Cup will be held this year. Soccer, cricket is extremely popular in India and other states in South Asia. And racing are the most corrupt games in the world. Soccer is definitely number one. The illegal revenue arising from soccer betting amounts to 0.5 trillion US dollars per year just in Europe alone. So this is the scale of the problem. As I mentioned earlier, it is due to a lot of online betting market and definitely infiltrated by organized crime and money laundering operations. On any given day, especially during weekends, in the Asian markets, whether it's Hong Kong or in Singapore or in Macau, there is a lot of online betting going on. As I mentioned earlier, the illegal revenue from soccer, from football alone in Europe, the amount is staggering. It comes up to US 0.5 trillion, and that is 500 US billion. So what do we have to do? We always have to understand the financial and social cost of sports corruption. And usually, severe punishment is the norm, raising the proportionality between what is wrong and the degree of punishment. And life exclusion is one of the severe penalties, the punishment for sports corruptions, life exclusions. Now I talk about another area called sport fixing. Now sport fixings usually does involve only one athlete. Now the purpose is to produce a determined outcome in any specific part of the sport. For example, how many yellow cards will be given in a soccer match 45 minutes from the beginning of the game. Or in cricket, how many runs. And very, very interesting in sports law and in sport tribunal, which is very different from our practice of law in the common law jurisdiction, or some of you are practicing law in civil law jurisdictions, right? Circumstantial evidence is admissible. If it is not impossible, then definitely it's impossible to convict anyone based on direct evidence. Now, circumstantial evidence is admissible, right? For example, there is a telephone incident at the Beijing Summer Olympics 2008. Now, I will give this as an example. I will not mention the case, but I'd like to discuss this with you. There was an incident of an official from a particular continent surrounded by numerous national representatives from one continent. And he was making many telephone calls, many from a public telephone in Beijing. This was an incident arising from the Beijing Summer Olympics 2008. So I was asked to be the investigator and adjudicator. So I asked him one question: why did you make so many telephone calls? Why did you make so many telephones conversations? With whom? His reply was, I'd like to have your monthly telephone bills, the invoices from your smartphone operators. His reply was, I make all the telephone calls to one person, my mother. Then I say, could you produce the telephone bills? And his reply was very interesting. No, my mother picked up the telephone from a public phone in Europe. And my next question, how old is your mother? And his reply, My mother is 81 years old. My conclusions, guilty, based on circumstantial evidence. Next, please. Anyway, I do welcome today, it's a very interesting group of participants. We have participants today from 4 continents, Europe, Asia, North America, and Latin America. Today we welcome participants from 4 continents. Now, the sense of the Olympic Committee at the 2011, the Olympic Committee, the Summit on Combating Corruptions in Sport, that then IOC president said, betting leads to manipulations of competitions and therefore threatens the integrity of sport. Cheating driven by betting is undoubtedly the biggest threat to sport after doping. It is a very serious threat after doping. Now, the IOC and sports integrity. IOC, the Olympic Committee, did establish an anti-corruption unit to tackle ethical issues with an emphasis on education and risk prevention. Education and risk prevention. The IOC also entered into serious discussion, and MOU, Memorandum of Understanding, was signed with the Interpol, International Police, to promote sports integrity following the 2011 Winter Olympic Games. So that has to do with IOC and sports integrity. Now let us turn our attention now to anti-doping in sports and the regulatory framework. I have this book, the latest editions of Louis QC on Sports, the Law and Practice, the first editions. The essence of sporting spectacle is a contest on a level playing field. It's very important to emphasize this word, level playing field. The usage of illicit drug strikes at the very heart of that spectacle. The outcome depends on unnatural performance. And usually, even the consumption of illicit drugs, they do pose very serious health hazards to the athletes. It is very serious, right? That is anti-doping in sports and regulatory framework. Now we come to anti-doping in sports and regulatory framework. There is a World Anti-Doping Code 2004, and the aims and purposes of this are as follows. Why was this bylaw enacted in 2004? 1, to harmonize. No, before that, please. The list of prohibited substances and methods. Number 2, to set up anti-doping rules and regulations and regulations. It is also to have some standard in punishment, in sanctioning regime, right? And then you must have some mandatory standards for sample collections and analysis, right? You have some cases, like in China, you do have some controversial cases arising from the Chinese national superstar, Sun Yang, for example, that had something to do with sample collections and analysis. Then anti-doping agency WADA. is set up to administer this World Anti-Doping Code, right? Then the Court of Arbitration, or CAS, is the final judicial platform and also the ultimate platform for any interpretations and applications of the 2004 Anti-Doping Code. Now, anti-doping in sports and regulatory framework. Why do we need to have this? We have to upheld the spirits of sports, right?